Mr. Wright, may I ask just about your basic argument here? And I'm just going to read you a sentence from the brief, and I want to know whether, that's your essential argument. It says, the government has yet to find even a single American jurisdiction that adopted a similar ban while the founding generation walked the earth. So is that what we should be looking for? And if we don't find that similar ban, we say that the government has no right to do anything?
Your Honor, I think that's largely what Bruin says. However, I don't think it has to be so narrow. So if the government could affirmatively prove from the historical tradition of either American firearms laws, or even I would be willing to spot them the way that we have treated other fundamental constitutionally protected rights. If they could tie it to one of those historical traditions, that would be good enough under the logic of Bruin, if not the exact rule of decision.
Because I'm not quite sure what the answer means. I mean, I took that sentence to be saying we're looking for a regulation that, even if it's not every jot and tittle, is essentially targeting the same kind of conduct as the regulation under review. And, the Solicitor General told us that was the wrong approach, that what Bruin really directs courts to do is to think about the various principles that were operating at that time, whether those principles gave rise to a particular regulation that was near identical to the one under review. And so I guess I'm asking you to comment on those two ways of understanding Bruin.
I think both methodological positions lead to the same result, which is affirmance of the decision below. It's not just something that is about domestic violence or a ban that's punishable by exactly 10 years. In other words, that's the way that some of the amici have described what we're arguing for. I'm saying there's no ban. There's no history of bans for people who were part of the national community. They don't exist. I'm saying that the plain text of the Second Amendment, the way that it distinguished from the English common law tradition, I'm saying that the early commentators like St. George Tucker and William Rawle, they all said, if you're just keeping the firearm.
So, but that does suggest, that you're looking for a ban on domestic violence. 200 some years ago, the problem of domestic violence was conceived very differently. People had a different understanding of the harm. People had a different understanding of the right of government to try to prevent the harm. People had different understandings with respect to pretty much every aspect of the problem. So if you're looking for a ban on domestic violence, it's not going to be there.
Justice Kagan, I'm looking for a ban. I'm looking for a ban, a criminal punishment for just the keeping of a firearm. That's what I'm looking for. And it's based not on the loss of status of citizenship, or being outside the community. I'm looking for a ban that applies to a rights-holding American citizen. I'd start with that. Short of that, again, and I suspect the response to that is this court has tentatively approved felon in possession, but felons are so different. They have all kinds of process. There's a long tradition of denying people convicted of infamous crimes all manner of rights of citizenship or not. So if I could just set that aside, there's no ban. Because at the time, when the people of the time actually wrote about it, they wrote that there's no right to misuse a firearm. So the allegations that are made against my client, we do not contend that behavior is protected by the Second Amendment. The behavior that's protected is the keeping of arms. The behavior that is also protected is the carrying of arms, but I would concede there is a strong historical tradition of providing more restrictions against the right to public carry, because that's where you encounter other people. This is someone who is keeping a firearm in his own home. The oldest American tradition, at least of a federal government, someone who everyone agreed was subject to the Second Amendment, passing that kind of law, was 1968. This tie is older than that so-called tradition, Your Honor. It's 20th century, late 20th century. And so we disagree at a very fundamental level of whether there is this tradition.